Oh, okay. He's a, let's see.
All right, Mr. Wood, are you ready on Mr. Turnage?
Judge, we are. I can inform the court of my conversation with him today, if that's what you'd like.
Yes, sir, please.
So I sat down with him for a good, probably at least 30 minutes, Judge, and he seemed to be in good spirits. We had a good conversation, but at some point during the conversation, it kind of reverted back to the things that he continues to talk about just about every time we are together. And also, as I think you've probably noticed, even when he is set for a hearing, he'll kind of go into these things that are occurring in other places. And he did the same thing today. I did explain to him the situation, explained to him obviously that he's moving up on the list. I think I talked to Ms. Taberham. I think he's at 96 or 98, something along those lines, Judge. So he is moving up, and I did explain that to him, and I explained the fact that we're just going to have to send him to the state hospital to make sure that he's okay, to make sure that we can go forward on this before so that we all feel comfortable. And he understood that, but he's still not in any way, shape, or form, Your Honor, thinking that anything is wrong with him, nor, in my opinion, have I really been able to make a whole lot of headway as far as just communication.
Gotcha. All right, let's continue to do what we've been doing. Let's reset Mr. Turnage. Let's set him out to January.
That's fine, Your Honor. I'll go back in a couple weeks and check on him as well.
How about January 3rd? Are you out on January 3rd at all? Or we could do January 24th.
But let's, if possible, Your Honor, if we could do January 24th, I think that would probably be a safer bet.
All right, let's set Mr. Turnage in just for a status on his hospital wait list, January 24th at 1:30. And of course, Mr. Wood, if you want to appear via Zoom that day, it's not a problem.
Okay. Thank you, Your Honor. Good to see you this morning and this afternoon.
Yeah.
Talk to you later.
I appreciate you, brother.
All right, man. Talk to you later.
We have any other counsel that's ready? Mr.
Right.
Schmidt. All right. Who do you want to go on, Mr. Schmidt?
Aaron Alvarez first.
Alvarez. All right, Aaron Alvarez, CR 22-262, 263, 264, 265. Set for, let's see. Sorry, I'm having to work off my phone here. Raymond on all those, I believe. Is that right, Mr. Schmidt?
That's correct, Judge. We received indictments in each case. Mr. Alvarez's name is spelled correctly. He stands as charged. We wait for him. As they all be separate from each other.
All right, court will. What setting did you like?
I think that
12-13?
yes, sir.
Okay. All right, court will find Mr. Alvarez has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record. Court will set all cases for pretrial on December 13th at 1:30. It'll be at 9 a.m. if he makes bail. And I believe on that day, we're in JP2. So. You like this?
Joshua Morgan.
All right, Joshua David Morgan, CR 22-279, CR 22-309, set for arraignment on each case.
That's true, Judge. At this time, we received those indictments. Also, wait for reading it spelled correctly. And I pleaded not guilty today. However, I've been negotiating with Mr. Woodward on a resolution to Mr. Morgan's cases. I believe that we will have, and I haven't, my last communication with Mr. Woodward was a few minutes ago. So the update from our side is that I think we have a resolution and we'd like to get it set on the Thursday docket. Could. Please.
Thursday of this week,
Yes, sir.
Mr. Woodward.
Judge, that's true. We've extended offers. Mr. Schmidt has accepted those offers. We believe we can get the paperwork done by Thursday. Yes.
All right, we set Mr. Morgan then for Thursday, October 13th at 1:30 for plea. Who do you like next?
We have Adrian Gutierrez.
Say Gutierrez.
Yes, sir.
Adrian Gutierrez, 2021 102-176, CR 2168. Show that we're set for docket call on all three.
That's correct, Judge. And as you recall, I think Mr. Gutierrez was on the jury selection with the prior counsel. I've had an opportunity to visit the state, ongoing visit with Mr. Gutierrez. It's my understanding that the last offer made by Ms. Heisler was the best it's going to get. Mr. Gutierrez is not going to accept that. So if we could put him on the trial docket, and we will just push forward from that perspective.
And Ms. Heisler, can you restate for the court what the best offer is?
Judge, did I hear that this is Mr. Adrian Gutierrez?
Correct.
I believe this is Mr. Woodwhite's case. I'm having a hard time hearing the jail court. It may be on my end. Let me look.
I'm having a difficult time as well.
That's because I'm whispering.
Mr. Woodwhite, do you know what your last offer to Mr. Gutierrez was?
I'll have to check. It was sent to Mr. Crane, and basically he said that they were not interested in an offer. Let me check my email real fast.
And based on I had a meeting with Ms. Heisler. I think Mr. Woodwhite was out, but I'm pretty sure my last offer was from here, like it was for TDC. Yes, yeah.
I never made an offer. I asked Mr. Crane if he wanted an offer, and he said that there was no need.
Yeah. And Mr. Schmidt believes he called Ms. Heisel, though. I think she's checking to see if she had extended an offer.
And Judge, I do not recall making an offer in this case. I have a hard time believing that I would, knowing that Mr. Woodwhite has been working on this one for a while. I have nothing in my email to indicate that I've spoken with Mr. Schmidt about this case. Nothing in my notes and nothing in my memory, Your Honor.
Mr. Schmidt, is it worthwhile to reset the case for a docket call before we go on jury selection to see what the state's offer is, if any? Or is Mr. Gutierrez of the position that doesn't matter what's being offered, it's going to be rejected?
Well, Judge, I like to split it right down the middle. And go ahead and put it on trial docket so Mr. Gutierrez can get in line. And then if the court will allow me, I will continue to talk to the state and clarify all the offers. And if it's something he wants, we'll just ask the court to hear it. If that's okay, we can do both. Yeah,
well, I tend not to want to do that, though, because that gives everyone the incentive of not taking a plea bargain until it's jury selection time.
Whatever the court wishes to do.
All right. State, what do you want to do? Do you want to make an offer?
Judge, if we could set it for one more docket call, I don't believe that will impact Mr. Gutierrez's position on the trial list if we wait 1 month. So Mr. Schmidt and I can fully negotiate having fully talked with Mr. Gutierrez, see if we can't reach some resolution. If not, we'll set it back on the jury trial list.
All right, court set Mr. Gutierrez for docket call December. You want November 8th or would you rather have, you're pretty full on that date. You want December 8th or do you want, I'm sorry, do you want November 8th or that December 13th?
November 8th is fine, Judge.
All right, court sets Mr. Gutierrez then for docket call on November 8th, and we can reach an agreement. We'll do it that day.
Yes, Your Honor.
Who do you like next?
Esteban Mendez.
I'm sorry, say that again.
Esteban Mendez, CR 22-243.
All right, Mr. Mendez is set for pretrial.
That's correct, Judge. And on the rest of the court's memory, the last time we were in court was for an arraignment. At that point in time, we entered a plea of not guilty and asked that we proceed to trial on the matter. I know the court set the pretrial for statutory purposes, but at this point, we don't have any contesting. We're ready to trial, so that would be an announcement today.
Okay, so you're ready to just go straight. He's ready to go straight to the jury selection docket.
Yes, sir.
All right, and he understands the court's policy on that.
Yes, sir.
Okay. All right, court will set Mr. Mendez then for jury selection beginning October 31st.
Are you waiting on me?
No, I'm sorry. Real quick on Mr. Mendez. Who you like next?
Matthew Coleman.
Yeah, I don't know. I think the jail's like real echoey today. I'm having a real hard time hearing too. Say that again.
Matthew Coleman, CR 22-268. Except for an arraignment.
All right, go ahead.
Judge, we received the indictment. His name spelled correctly, waived formal reading, enter plea not guilty. Ask that it be set for pretrial.
You want that December 13th?
Yes, sir.
All right, court finds that Mr. Coleman has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record and sets for pretrial on December 13th at 1:30, 9 a.m. if he makes bail.
So,
All right,
Philip Hollister.
all right, Mr. Hollister. This is CR 21-293, motion to revoke.
That's correct, Judge. Still negotiating with the state. I don't think we've got any, what I would consider substantive conversations about resolving the matter, but if we could set Mr. Hollister on your next contested docket, perhaps we can get something done on that.
Looks like our next contested is October 27th. That's a couple of weeks. Is that time?
Yeah, I think it's fine, Judge.
Okay. Court sets Mr. Hollister then for contested hearing on the motion to revoke October 27th. That'll be at 1:30.
Oh, no, that's not. I'm not. Yeah.
Who you like next?
Judge, the only inmate I have in here right now is Matthew Estrada. That was set on the plea docket. I'm trying to track down papers. So I'll bow out for now until it brings some folks.
Okay, thank you.
We got Mitch Adams here. Bill Stevens.
Mr. Stevens, Mr. Adams, either one of you ready to go? You want to step on up?
Judge, I'm waiting on my client. I think Mr. Allen's might be there.
Okay. Josie Bohannon, CR 22-2, so for arraignment.
Your Honor, could you repeat that cause number for me?
Yeah, CR 22-2, 4 zeros and a 2. Josie Cheyenne Bohannon.
Very good. Thank you, Judge. And are we on the record? Ready to
Yes.
go?
Yes, we're ready.
Because I had to ask the court to read me the cause number, that means I don't have a copy of it, or I haven't looked to find out whether or not it's available to me, probably the latter. So I say that so that if the court could display a copy of the indictment for Ms. Bohannon and I to look at together to cover that base, and then we can proceed.
State, can one of you display the indictment? In this case, I don't have access to my LGS.
Yes, Judge, let me grab that really quickly.
I'm already in it. Oh,
And Judge, I can't see what you can see, so let me know what I need to do.
I would say in
You're doing a great job, Ms. Harvey. You have a future in IT. Thank you, Ms. Harvey. All right, Judge. Ms. Bohannon and I have just now had the opportunity to review a copy of the state's indictment. Ms. Bohannon, I can advise the court that Ms. Bohannon's name is properly spelled and set forth in that instrument. She understands the allegation brought against her in that document. We would waive the formal reading of the indictment, enter a plea of not guilty, and ask the court to set us for a pretrial hearing.
All right, court will find Bohannon has waived the formal requirements of arraignment. Court will enter her plea of not guilty for the record. We'll set this matter for pretrial hearing. Are you available November 8th or 10th, Mr. Adams?
November 10 would be an ideal day.
Okay. All right, court sets this matter for November 10th, 1:30, 9 a.m. if she makes bail.
Yes, sir. Your Honor, that's all I have on the docket this afternoon. I'll pray. Excuse.
Yes, thank you, Mr. Evans.
It's a Christmas miracle. Thank you.
We have anyone else that's ready?
Yeah. Are you ready to go?
All right, Mr. Stevens. This is Ms. Pentler.
Yes, it is, Your Honor.
All right, CR 22-283-284, State versus Nicole Lynn Pentler, set for arraignment. Go ahead.
If it may please the court, Your Honor, my client would advise that the name spelled correctly, you should understand the nature and the consequences of the charges. We will waive reading of the indictment and replace a copy.
All right, the court will find that Ms. Pentler has waived the formal requirement of arraignment. Court will enter her pleas of not guilty into the record. And we'll set this matter for pre-trial. Are you available on November 8th or 10th?
The 10th, Your Honor.
All right, court sets Ms. Pentler then for November 10th at 1:30. And it'd be 9 a.m. if she makes bail.
All right, so, and Ms. Hassel, could you put the discovery on the portal for 0284, please?
I will.
Thank you. Would I be excused, Your Honor?
Yes, thank you, Mr. Stevens.
Thank you, Judge.
Go ahead, Mr. Schmidt. Who are you ready on?
Jamie Nash.
All right, Jamie Nash. All right, this is cause number CR 22-338, set for arraignment.
That's correct, Judge. We received the indictment. Everything's spelled correctly. She understands the charge. We waive formal reading and her plea of not guilty. As it is set for pre-trial.
All right, the court will find the formal requirements of arraignment have been waived, and the court will set this case for pretrial. Well, the court will enter a plea of not guilty into the record and set this for pretrial on December 13th.
Yes, sir.
And that'll be at 1:30. I've got Mr. Weiner in the online Zoom, but I don't see that Mr. Weiner's on the docket. Do y'all have Mr. Weiner on the case today?
Judge,
Mr.
he
Head
was-
has a case.
He was set on Holly Mormon. He's handling that case for Mr. Head. But we requested a bench warrant from TDC, and my understanding was that we couldn't get her back here on time. I'll defer to Ms. Tabraham on that, but that was my understanding, was that he was previously set on Miss Mormon, but our bench warrant couldn't get served in time.
I don't have her on the docket today. She must have been removed because of that reason. Ms. Taberham, if you want to contact Mr. Weiner, I don't have her on the docket today, so if you
Your
want
Honor, I have her on page 9.
page 9 under head or under Weiner,
Head.
head on page 9. And sorry, I'm having to do this on my phone, and so it's very hard to see.
And I did ask him to appear to make an announcement.
Okay, there she is. Motion to. Okay, all right, let me bring. And Ms. Taberham, what about Cole on Robert Crane? I think Zoom that's in the waiting room is probably Wood County.
Yes,
But
sir. I'm trying to get a hold of him.
I don't see Curtin, so when you, yeah, if you can get him ASAP. It's a little bit-
Okay, all right.
Good afternoon, Mr. Weiner.
Good afternoon, Judge. How are you?
I'm okay. I'm living. This is cause number CR 16139, State versus Holly Elise Mormon. I think we were set on maybe plea her today on motion to revoke. Understand that there was some bench warrant issues. I guess she's down in TDC now. I guess Smith County shipped her out, I think.
That's my understanding. My understanding was there was a hold while she was in Smith County. We have an agreement. She has the back time for it. It's just a matter of actually getting her here without, ruffling any feather. I've never, 3 years ago, other judges rejecting other judges' bench warrants was unheard of. And now it's just like common practice. So unfortunately, this is happening not just in your county, but kind of all over East Texas that I've experienced. So it's just a matter of getting her in court, Judge.
Okay. So we just need to do another bench warrant and reset her for another date.
Yes, Your Honor.
All right, let's look at your calendar then today. I've kind of been resetting everybody today to either November 8th or 10th. If is she looking to parole soon or anything? Do you know?
They're both state jails, and she will essentially be time served on the charge out of this county. She'll have a little more time to serve out of Smith County. I'm not set in either. Let's see. Let's look. If we could do the 10th, that would work better for my schedule.
I mean, I don't mind setting it further out too, if y'all have an agreement and there's no rush to get her.
I'd rather go ahead and try just because I think this is like our second or third attempt. I'd rather try and get it done, Judge.
Okay. All right. Court will set Ms. Mormon then for plea on November 10th. And we'll get the bench warrant done and sent out. And maybe we can get her in time.
Thank you very much, Judge. That's all I have. May I be excused.
Yes, sir. And that'll be at 1:30 if I didn't mention that.
Yes, sir. And thanks. I always appreciate the court letting me appear via Zoom from all over East Texas. So it makes my life a little easier. Thank you.
Hey, absolutely. No problem.
Y'all have a good one.
See ya. All right. I'm going to bring in Mr. Ashmore. All right, is Cornelio Reyes in the courtroom? CR 22-114. If Cornelio Reyes is not in the courtroom, what about Donnell Shelton? CR 22-47 and 48.
We're gonna get both of them by now, Your Honor.
Okay. All right, Mr. Ashmore, we'll have them up as soon as we can. We have anybody else
Yes,
in the
Judge.
courtroom that's ready to go?
So it's. Mr. Water, you ready? Mr. Watts, so just give him a couple of minutes or bringing up Mr. Ashmore's too. and then it'd be good to go.
Okay, all right. We'll wait for him then.
Judge, we have Mr. Reyes.
All right, this is cause number. CR 22-114, State versus Cornelio Antonio Reyes. We're set for docket call, and then I believe that there's a request to terminate court-appointed attorney. Mr. Reyes, can you hire your own attorney?
So,
Why not?
if I was free right now, I would be able to.
What does being free have to do with hiring a lawyer?
I'd be able to work and, given time. I don't understand why I'm here because I did reschedule with Casey Ashmore and Miss Patty Taberham. And I talked to my bail bondsman as well. And he just said that I got the warrant because Casey Ashmore didn't reschedule my court date. So that's why I'm asking to go ahead and terminate him. And he said that he would, and he's more than willing to remove himself from my case. Also, I did write grievance to the State Bar and Board, and my wife is also she is also sending an email to them. This is all to me, this is all a big misunderstanding because I did reschedule. I did have a doctor's note. I showed proof, everything checked out with Patty. She talked to them over fax, and everything checked out. So I don't understand why I'm incarcerated. My bail bondsman told me to wait for a new court date, and I'm waiting. And then the next time that I check in with him, he told me that I had a warrant for my arrest. So I don't understand why I'm incarcerated right now.
Well, let me help you understand, Mr. Reyes. First of all, nobody can reschedule a court date unless I approve it. I received all your documentation. Ms. Taberham brought it to me, and Mr. Ashmore on multiple occasions contacted the court and contacted the court coordinator to ask for your case to be reset, and I denied it because I felt like you could be in court. The doctor's note and the medical reasons that you sent in did not prevent you from coming to court and signing a reset and being here for 5 minutes and then leaving. There's people that come in wheelchairs and oxygen tanks.
Well, I mean, I was sick and I wasn't feeling well, and she just said that I needed my bail bondsman and Patty both said that I just needed a excuse.
Well, listen, your bondsman does not decide who comes to court and who gets rescheduled. They have no authority, zero authority. Okay, so
I was just trying to do the right thing, keep in contact.
but listen, I'm trying to tell you. You said you don't understand. I'm telling you, I made that decision, not Mr. Ashmore, not Ms. Taberham, not your bondsman, not your wife, not your mama, not your pastor. None of those people made that decision. I reviewed it and I felt like you could be here. So that's why you've got a warrant. You understand? And so going and filing grievances against Mr. Ashmore when he can't do what you think that he can do, that's on you. That's not on him.
Well, how come
He can't, hang on, I'm still talking. He can't dismiss your case. He doesn't have a magic wand. He can't do any of those things. Do you understand what I'm telling you? Do you understand what I'm telling you? Yes or no?
It seems a bit unfair.
I don't care if you think it's unfair or not. I get to make that decision, Mr. Reyes, and I make these decisions every day. And I review them over and over. And I really spend a lot of time thinking about them. And what I saw in your medical documents, as compared to everyone else's medical documents, I have people coming in wheelchairs. I have people who can't even walk. I have stroke patients. I have people who have been blind. They come to court when they're told to be there. They come in with wheelchairs. They come in with crutches. They come in with all kinds of stuff. They come in with personal assistance. So I felt like, based on my experience of everyone else being able to do that, your reason, and I don't think you want me to say what your reason was on YouTube and in this courtroom. I don't think you do you? You don't want me to tell everybody the reason you couldn't be there, right?
Given the opportunity, I mean.
Do you want me to tell everybody the reason you couldn't come to court?
No, I'm not saying that. I'm just saying.
Okay. All right. I'm saying then you know I'm right. If you don't want me to tell everybody the reason you didn't come to court, then you know I'm right. What are your other complaints with Mr. Ashmore other than he hadn't had your case dismissed and he didn't get your hearing reset? What are your other complaints against Mr. Ashmore?
You mean,
Well, you filed a complaint against Mr. Ashmore, didn't you? You said you filed the grievance with the state bar.
because he told me that he rescheduled it for the 2 days after, and he never rescheduled for 2 days after. On top of that, he didn't really communicate with me about anything. He just kind of started strong on me, and I really couldn't make it to court. I mean, I lost my job. I didn't have gas money to go to court. I live in Greenville.
You didn't have anybody that could drive you to court to keep you out of jail.
No, sir.
Nobody. A boss, a mom, a dad, a sister, a friend. Nobody could drive you.
My sister at the moment was in Eagle Pass with her boyfriend was stationed. He's in the military. And that she's really kind of the only family I got. My mom, she's taking care of my kids right now. She's kind of already tight on money. I was working on towards getting my kids back. And I mean, that's something that I try to talk to you about in court. I'm just saying, I mean, I try to do the right thing is all I'm saying. I try to keep in communication with you guys. And I didn't really understand, but I guess you're right. I mean, if you make the decisions, that's you.
And I'm not trying to tell you that I make the decisions and you just got to live with it. But I'm telling you, I read what you sent in. I read your medical records. I talked about it. And I felt like you could be here just like everyone else. That's why I'm telling you I made the decision I made. And it was my decision. Mr. Ashmore, he worked hard to try to get it reset. He urged it over and over again, and I denied it. These attorneys that appear before me every day, they want things all the time. They want things from the state. They want things from the court. I deny them. That's just the nature of the justice system. So I'm sorry that you think it's unfair, and I'm sorry that it's inconvenienced you, but it's your job. It's your job to make sure you're at court. And if you're not excused and you don't have an order from this court saying you're excused, then you got to figure out a way to be there. I mean, you made bond in this case, right?
Yes, sir. I also thought that I was in the clear because Patty did say that everything checked out, everything was all right. So I guess I was kind of misled or confused about it.
Okay, well, let's ask Ms. Taberham. Did you mislead Mr. Reyes?
No, sir. I told him that you would look at the excuse. He was set on one day. We didn't get the excuse was like for 2 days after that. I think it was August the 23rd, and the note had August the 25th. You had me call back and find out why there was a 2 days difference. No, I did not mislead him.
Thank you, Ms. Taberham. So there you go, Mr. Reyes. Mr. Ashmore, we're talking a lot about you, but we're not talking to you. You want to respond?
Judge, thank you. This is a matter where, the state has been, I think, extremely reasonable for attacking a peace officer in the line of duty, in the commission of their official duty in the state of Texas. Intoxicated and essentially throwing down with a police officer. The offer is 8 years, and it has more to do with the past than it does with the actual offense, because it's evident that Mr. Reyes' conduct wasn't intended to create the problem that he now has, but he's got prior convictions from when he was a young man that don't make him parole eligible or probation eligible, don't make him eligible to do or take any steps with SafeP or anything that could be an intense supervised probation to deal with his drug and alcohol problem, which he clearly has, and has admitted as such, right? That was a big reason why things went bad that night. So, and that all being said, there's been no strong arm. There's been watching of the discovery, watching the videos, discussions with him about the reasonable positions we could take, negotiations with the state prosecutors, and conferring with Mr. Reyes about, the ball's back in your court. Let's make a decision at some point. Whatever medical issue came up, he was advised he needs to be in court. He needs to get up to the courthouse and he needs to sign a pass slip It's important. It's required. I know that he's had some financial hardships. So he says, I don't doubt him. I take him at his word, but I also advised him he needs to get to the courthouse. He doesn't have, you can't tell me the morning of that you can't come to the courthouse. I understand you've got some medical issue. Get that. Still need to get up here and sign a pass slip. Like clients of mine that I have presented to the court who've been coming to court with a colostomy bag, who've been coming to court with a oxygen tube, with a leg in a cast. Still got to get up there and sign a pass slip, even if it's at the 1:30 docket. And I explained that, and I thought it was crystal clear. That being said, you know, I'll deal with the state bar when that comes. And I refute as strongly as possible that I've attempted to strong arm or failed to communicate with Mr. Reyes. That's just not how it went down. That's not true at all.
Thank you, Mr. Ashmore. Mr. Reyes, you want to be heard?
Well, I got all the emails between me and everybody, and that was sent in with the State Bar on board. I don't know. I guess my life is in y'all's hands, right?
Well, I think your life is in your hands, and you find yourself where you're at today because of what you do, not because of what we do.
I did not, personally, I feel that I'm innocent, right? I did not assault the officer. Things kind of just happened real fast. I seen the body cam footage.
Well, listen, I don't want you to talk about what happened. Because there's two prosecutors here that will take what you say and they will use it against you. And you do have rights, and we want to make sure that we protect those. So this is what I'm going to do, Mr. Reyes. I understand that the offer is 8 years, and it's my understanding that you're rejecting that offer. Is that right?
So,
Okay. Court's going to set you for jury selection beginning October 31st. You're going to remain on that jury selection docket until your case is reached for trial. And then we'll give you the trial and you can proclaim your innocence to the jury.
I thought the other offer was 6 years.
Well, it doesn't matter what the offer is now. So you rejected the offer. If you were looking to plea, you would have told me today that you wanted to plea. So it doesn't matter what the offers are now. The court's not going to entertain a plea agreement. So you're set for jury selection on October 31st, and we'll get to your trial as quick as we can. We'll put you in the list and we'll work your way up.
Is there any way that I can get my bond reducted back to 2,000 or 20,000?
You can file, you or Mr. Ashman can file a motion to reduce bond and I'll consider it.
Well, I speak to Mr.
Probably not a good odd though. October 31st, jury selection.
Are you gonna still from my case, Mr. Ashmore?
What'd you say, Mr. Reyes?
Is he gonna, he told me over the phone that he was more than happy to remove himself from my case.
Well, I'm not removing Mr. Ashmore right now. Mr. Ashmore can't remove himself from your case. You see?
Yeah, I want to clarify, Judge. I never said that.
I appreciate it.
He said he was filing the motion. He told that to my staff. Mr. Jackman is actually who we spoke to. I wasn't in the room at that moment, but Mr. Jackman did put him on a hold, asked me and I advised Mr. Jackman to tell Cornelio he can file whatever motion he feels like he needs to. But I'm aware I can't remove myself. I serve at the court's discretion.
Thank you, Mr. Ashman. Mr. Reyes, you're indigent and you've requested court-appointed counsel and the court has appointed Mr. Ashmore. There's a limited number of attorneys that serve in this capacity, and I find no grounds to remove Mr. Ashmore from your case based on what you've told me as why you think his performance has been insufficient, while the basis of your complaints are nothing that he has control over. So I'm denying the motion to remove Mr. Ashmore at this time. So we'll see you soon.
God bless you. Huh?
Are you ready for Mr. Shelton?
Yes, Mr. Shelton. Donnell, Giroux Shelton, CR 224748. Looks like we were set on status, and then Mr. Shelton's he's asking for the court to remove Mr. Ashmore. Is that still your position, Mr. Shelton?
Well, lately he's been trying to show that he's interested in my case. Until I filed, the grievance and everything against him. Like, I've been having asthma since last year. First time I ever saw him was 6 months ago in March when I had my first COVID. I wrote him back in November, asking him certain things, to come see me, but I never, saw him until March 6th. Then he had told me I wasn't his client back in November. But I had an energy paper saying that he was my lawyer in November with his address, name, and everything on it.
Mr. Ashmore, have you had an opportunity to review the written complaint that Mr. Shelton filed in September?
Judge, I've had an opportunity. I have an understanding about it. I think there's a couple of things going on. There's some misunderstandings between Mr. Shelton and I, which I think we've both worked hard to clarify. He also lost his little brother in the last 45 days, which I think could only affect him emotionally because he can't be out there to comfort his family. I think we've resolved whatever issues, and it's not uncommon for clients who are stuck inside to feel frustration, and even with the ability to meet with the video conference machine, which doesn't always work, but it is a blessing that we've mended our fences. At least that's my understanding of our relationship, and that Mr. Shelton and I are in communication, and we are working as a team. And I think and I believe he feels that way as well. But I also understand, whatever delays in communication that we've had, and the frustrations, of course, like I've articulated, that he lost his brother. He can't get out there and see his mother or his family members. And I believe that's all been resolved between us.
Mr. Shelton, what do you think?
That's part of it. I just want to say that, don't show that he's got my back, got interest in my case. Certain things I need to be doing or we need to do. Showing him now, I don't know how he did it. I didn't write him up. I think that kind of probably help things out. Even though there's we're not supposed to do. Things like that he knows now, he should move back 6, 7, 8 months ago. Dealing with situations I'm going through. Things that I'm facing.
Tell me, Mr. Shelton, what has Mr. Ashmore done or not done that you believe that he's required to do as your lawyer?
Well, just keep in contact with him. I don't text him a couple times on the kiosk, never got to respond back. It's like, out in the world, you maybe know something, but and it should be the same way in Europe. Even though you is locked up, but you should still be able to see your lawyer and talk to him. Just keeping you, in the spirit that he have your back. That he's gonna fight. Whereas I didn't do none of that. So how you think they gonna make you feel?
What else? Anything else?
It's a lot of things that us inmates go through. Sometimes we feel that ain't nobody here to help us. Some people just don't care. And, we get blamed for probably writing them up just to see how things gonna change for both of us. That's how I feel at the time.
So you feel like the fact that you feel like he doesn't communicate with you enough, and therefore that shows that he has a lack of interest in your case?
Yes, sir. Then at first, like, I feel like he didn't care at all. You know, first minute, I was just talking certain things he said to me, what gave me that presumption. That he really didn't care.
And how often do you think he should be talking to you about your case?
Well, since I wrote him up, it's been twice. And it was, I think, 1 or 2 times before that. When we saw the video and before the video.
So how many times do you think he should be contacting you about your case?
At least a couple times before, we go to court or about a discovery, anything, or anything that he gets on fine. I feel, I should be on date that because I probably could tell him certain things would happen. That he might need to know.
Mr. Ashmore, anything else?
Yeah, Judge, real quick, we've had a number of meetings, both video and in person. And prior to having meetings where we got to review the videos, there were some issues with the videos. We had incomplete set. And I don't know if the court or the state recalls, but early in the summer, we actually had a contested pretrial hearing, a discussion about rejecting the state's 40 plea offer. But there was also the issue of we just had an incomplete set of the videos, and there's video surveillance from 4 different LEOs, Tarrant County officers. Dallas, I don't think ever turned in anything. Sorry about that, Judge. Dallas, I don't think ever turned anything, but Kaufman, Van Zant, and some city units. And essentially, Mr. Woodwhite with the state prosecutor's office and I did an audit over the summer and ensured that we had asked for and flipped over all the rocks to ensure that we had a complete set of the videos. And I think that's understandable with the fact that this is an offense that is alleged to have occurred across 4 counties. We just needed to ensure that we had all of them. We had videos that were related to other cases, but not videos related to this case. And the state has done what I believe they're required to do and turned over, done a recollection and download and gave us new copies of everything that pertains to Mr. Shelton's case. We've now had time to go through all of that, discuss that, go back to the state, discuss plea offers. And like I said, I think a lot of this comes from some other emotional things that are the subject of family pressure from being inside and not being able to do anything about it to help, to support, to give the love and affection. So I still serve at the court's discretion. I think we're in alignment. I think we're in communication, and I understand the reason why there's some frustration because we didn't have all the information, and now it seems like we do. And we've had some good discussions about what our position is going to be going forward.
All right, Mr. Shelton, the court's going to deny your request to replace court-appointed counsel. However, you're not precluded from alleging or filing the motion again. You understand? All right. I don't show that we were set for anything else today. We're already on the jury selection docket, correct?
Yes, we are, Judge. We are.
And I'm not sure if we're special set or not, but this may be a case that needs to be special set. Would you agree, Ms. Heisel?
Yes, Your Honor. I believe that because there are so many from other jurisdictions, that would be in the best interest of everybody.
All right, court will consider that at a later date, and if we get a special, I'll contact counsel.
Yes, Judge.
All right, thank you, Mr. Shelton. Is that all you have today, Mr. Ashburn?
I I think we have Peters. Is he, or did he make bond again? I'm not sure.
It's a good question.
I didn't show Mr. Peters. Was Mr. Ashmore's yelling to get him?
Were you appointed to him? We don't have your name
I
on the
will,
document, but you could have been appointed. CR 21-304. Miss Tabram, do you know if Mr. Ashmore was appointed to Matthew Ryan Peters?
I'm sorry. Yes, sir.
He was appointed.
I didn't hear the question.
Was Mr. Ashmore appointed to represent Matthew Ryan Peters? Motion to revoke CR 21-304. It's not on our docket, but Mr. Ashmore asked about him.
is it a motion to revoke or a DWI third?
My docket says motion to revoke on a DWI third.
Oh,
Hang on just a second.
After
Okay, I
this,
show that Mr. Ashmore was appointed back in January the 21st of 22, but that was before it was a motion to revoke.
okay, so what I would do is inquire, do you have any objection to being appointed to him if he says that he's indigent and the court finds him to be indigent?
no, I still have the share file open, and the state recently sent, I think, well, maybe looking at last year's letter, but I think I have an offer letter. But that might be from when the case was still just, I guess it's last year, never mind.
Okay. All right. Well, no, you're good to go. If you get appointed, we'll send you notice.
Yes, Judge.
I'm going to bring him over. You can stand by if you want. And I'm going to inquire with him on what he wants to do. I believe, Ms. Tabram, is this the one that you were telling me you sent over the application and he never turned it in? Yeah, she said that she sent an affidavit.
Yes, sir.
But he's not completed it or so. Anyway, Mr. Ashmore, I'd probably say save your time and go about your business. And then if we find him to be indigent and if we appoint you, then we'll send you notice.
Yes, Judge. Thank you.
All right. Thank you, sir.
Thanks.
All
Sir.
right. I'm going to bring in Mr. Knoll and Mr. Crane, I believe.
Afternoon, Judge.
Good afternoon, Mr. Knoll. How are you?
Pretty good. Do we have Mr. Crane in?
I'm trying to bring him in now.
Okay.
We were waiting on you.
Sorry.
It's all right. There he is. Oh, I'm sorry, staff. Click that unmute for me again. I think I was clicking the same time you were clicking. Perfect. Sorry about that. All right, Mr. Crane, can you see and hear me okay?
Yes, sir.
All right, this is CR 21-56, State versus Robert Cecil Crane. This is just docket call. Mr. Crane is appearing via Zoom from Wood County. I do appreciate Wood County assistance in conducting this Zoom court hearing. Mr. Knoll, any announcements on docket call?
Judges, as far as the case in Van Zant County, I think we would be ready. It's kind of I'm kind of in a awkward position. He has He has 3 charges, as the court may recall, a similar charge as to Van Zant County in Wood. And I believe it's 2 assault on a public servant charges. As far as I know, those are still pending. And I have today no idea if they are set for trial or not. Maybe Mr. Crane knows more on that than I do. As far as I know, they're not. I know that they were short a prosecutor there for a while, but I think that's been alleviated. So maybe that'll make that case move faster.
Mr. Crane, do you know if you were set for trial in Wood County?
No, sir, I'm not set for trial. I've already signed.
What did you sign?
10 years.
Oh, plea agreement?
Yes, sir.
Okay, when did you do that?
On the 1st of last month.
September 1st?
Yes, sir.
Okay, are all,
I'm just waiting for a chain right now.
okay. Does that conclude all of your Wood County business?
Yes, sir.
Okay, all right, well, that's helpful to know.
Judge, if I could ask you, was that on all 3 charges?
One was 1244A, and then 2 of the charges was one for the assault on the public servant and the indecent exposure. I signed for 10 years on both of them.
Okay.
And then a 1244 time served or something on the other one, the third one?
Yes, sir.
Yeah, I don't think it could have been a 1244A because that,
1245, excuse me.
1245?
okay, that it could have been.
Okay. All right, well, that is helpful. Thank you, Mr. Crane. Okay, so what we need to do then is make sure that we have either we need to get Mr. Crane transported to Van Zant County, or we're gonna have to catch him once he catches the chain. So,
And Judge, it's my understanding that we do have holds on Mr. Crane for our charges in the event that he was ever released from Wood County. I don't have access to that side of the jail system to confirm that those are still active, but I know at one point we did have active holds on him.
Judge, that was I'm sorry, that was my understanding also, but as Ms. Heisel indicated, I have no idea if those holds are still active, but they were at one time.
They are.
they're still active. All right, thank you, Mr. Crane. Okay. So is this case bound for trial, Mr. Knoll?
I probably need to talk to Ms. Heisel again now that we're in the situation that we're in, since he's entered a plea to 2 felonies, although they are subsequent in time. They would be, I guess, subject to 404B 609 3707 type notices. Even though we've all known they've been pending, now there's 2 convictions apparently that set out there. So,
All right, let's do this. Let's set Mr. Crane for another docket call with this recent development that may change the landscape for both the state and the defense. So let's set Mr. Crane for December. Are you available on December 13th, Mr. Knoll?
that's fine, Judge. And if we have a resolution, if we have a resolution before then, I'll try to get back with the court.
Okay. And I wanted to set it out to where you had enough time to get him back over here if we need to, if we'd have those conversations. So, all right, court will set Mr. Crane then for December 13th. That's a Tuesday. It'll be at 1:30. And if y'all get the case worked out before then, let me know and we'll get him in and get it resolved so he can move on about taking care of his business.
Thank you, Judge.
Thank you, Mr. Crane. I appreciate you, Wood County Jail staff. Appreciate you very much.
Yes, sir.
Y'all have a good day, gentlemen.
You too.
Thank you, Judge.
Very well. And that's all Mr. Knoll has. All right. All right, who's ready now, Deputy Everett?
I got Mr. Nolan.
All right. Mr. White, who do you want to go on first?
Your Honor, we only got one. We passed Mr.
Oh, yeah, that makes it easy then. CR 21-162 State versus Dustin Lee Cook. And Mr. Cook is set for docket call. Go ahead, Mr. White.
Your Honor, we are going to proceed we're gonna enter a plea today in cause number CR 21-209.
Okay, and what's that charge?
That's impeding, airway.
Is this a new charge based on information?
No, sir, I believe this case was indicted.
Oh, is it a recent indictment? Well, it's
I
21.
wasn't originally, I'm sorry, Your Honor, for interrupting you. I wasn't originally hired on this. I thought, and I'll put this on the record right now, I thought that I could possibly have a conflict in handling these matters. I contacted the state bar, talked to a representative down there from ethics and explained the situation. It was her feeling that I did not have a conflict. I talked to Mr. Cook at length several times about this issue. I think he's comfortable with me proceeding, and we're just going to go ahead and enter the plea on CR 21-209, and then we're going to 1245 some cases with him.
Okay, Mr. Cook, I guess you've had these conversations with Mr. White. Do you want Mr. White to proceed as your attorney?
Yes, sir.
Okay, and so you've talked with him at length about that, and you're comfortable with any issue that Mr. White thought he may have had upon his investigation and now his decision to go forward. You're comfortable with it?
Absolutely.
All right. All right, Mr. Cook, do me a favor, raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yep.
All right, you can lower your hand. All right, Mr. Cook, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
Yes, sir.
And in this case, CR 21-209 and also CR 21-162, you are represented by your attorney, Mr. Nolan White. Are you pleased with his representation of you?
Absolutely.
Do you feel like you've had enough time to talk with him about your case and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read over and signed today that you do not understand? All right. And Mr. White, what are the terms of the plea agreement today? You said CR 21-209, which is an assault, family violence, occluding.
Yes, sir. As a condition or as plead guilty, punishment be assessed at 6 years in the Texas Department of Criminal Justice, Institutional Division, fine $1,000, which includes the $100 family violence fine. And the state is going to 1245 DA number 2020. Excuse me, Your Honor, I'm having a hard time reading.
That's okay.
DA 2022-850, which is an unlawful restraint, exposure to SBI, and DA number 2022-0851, assault, family violence, impeding, and then they're going to also 1245 CR 21-162.
All right, let's see, 290 court costs, any reimbursement fees?
There'll be a $70 reimbursement fee, Your Honor, and there's he's got 99 days of credit on this cost.
99 days of credit. Any restitution?
No, sir.
Okay. All right. So Mr. Cook.
Judge, sorry to interrupt. There is a weapon forfeiture of a 9mm JA9 model, serial number 39691.
Is that
I'm sorry, Judge, what?
is that in the proposed judgment?
Yes, Judge.
Okay. All right, Mr. Cook, you've heard the plea agreement read to the court by Mr. White, and then also about the weapon forfeiture from Mr. Woodwhite. Is that your understanding of the plea agreement?
Yes, sir.
All right, and so Mr. Cook, you understand that the range of punishment for an assault, family violence, impeding breath is not less than 2 years or not more than 10 years confinement in the Texas Department of Criminal Justice, and a fine not to exceed $10,000 if imposed. I find that this plea agreement would fit within the legal range of punishment. The court finds the plea agreement does fit within the range of punishment, and you're telling me that you do wish to go forward with your plea today.
Yes, sir.
All right, Mr. White, do you believe Mr. Cook to be competent today?
Your Honor, I do. I believe he's competent. I believe he understands the proceedings that are pending against him here today. We've executed some waivers. I believe he's executed those knowingly, intelligently, and voluntarily. I would also note to the court, and I don't know, Mr. Woodward, if he's got a judgment in front of him, there's also an enhancement paragraph I think the state wanted us to plead true to. Is that correct?
Yes, I think that is correct.
Yes. And I've explained that to Mr. Cook as well.
All right, thank you. All right, Mr. Then at this time, I'm going to ask you, how do you plead to assault, family violence, impeding breath or circulation?
Guilty, sir.
And how do you plead to the enhancement paragraph included in your indictment? Is that enhancement paragraph true or not true? Are you pleading guilty and pleading true because in fact you are guilty of committing that offense and that prior enhancement is true?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to make you feel like you had to make any agreements today?
Yes, sir.
All right, the court will accept this plea of guilt and is true. Mr. White, any objection to the state's evidence?
No, sir.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Judge, I would note for the record that the DA's office has not received the unlawful restraint, exposure, serious bodily injury, or new assault family household member that we are taking into consideration. They allegedly happened about 9 months ago. We do not have cases. So just so the court's aware, that's why we're including those. We're closing them out. We don't believe that he needs to be held any longer. We're not going to receive cases in this time frame. Beyond that, state would have nothing else to add.
All right, thank you. Anything further from the defendant?
Yes, I have something real quickly I'd like to put on the record. As far as the forfeiture of the firearm, there is no affirmative finding of firearm that it was used in this particular cause number, which is CR 21209. And we agree to the forfeiture of the weapon, but I would also note that he has no possessory interest in that weapon. That weapon belonged to his girlfriend at the time. But we are agreeing that he has no possessory interest and we're forfeiting it voluntarily.
All right, thank you, Mr. White. All right, then based on the evidence, the court finds that there is sufficient evidence to convict the defendant of this cause in cause number CR 21209. Court hereby convicts him of assault, family violence, impeding breath or circulation, imposes a sentence pursuant to the plea agreement at 6 years confinement in the Texas Department of Criminal Justice, orders him to pay a $1,000 fine. Court will take into consideration and dismiss under section 1245, files numbers CR 21162, DA 2022-850, and DA 2022-851. Court orders him to pay court costs of $290, reimbursement fees of $70. The court also awards the defendant 99 days credit towards the sentence for the time that he has spent in jail on this cause. The court finds the enhancement paragraph to be true, if I haven't already said that. And in addition, the court finds that the weapon used in the offense will be forfeited pursuant to the language in the judgment. Mr. Cook, you hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence and have you step over with a deputy to be fingerprinted. Good luck to you, sir. Mr. Schmidt, are you ready?
Ready on Matthew Estrada. We've got papers coming on. Ms. Robbins here in a second.
All right, Mr. Estrada. All right, this is cause number CR 240, State versus Matthew Estrada. Mr. Estrada, if you'll raise your right hand, sir. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you, sir. You can lower your hand. Mr. Estrada, are you a United States citizen?
Sir.
Do you read, write, and speak English? I'm sorry, go ahead.
Judge, Mr. Estrada said on a
Oh, I'm sorry.
motion to proceed. And what the agreement we've reached is to withdraw the state's motion, continue him on community supervision. He's the forfeit. How many days? 70? I don't know, look at it. Anyways, they're gonna eat up his credit time and he's gonna submit to safety as a condition.
Okay. All right, give me a second. No, I don't have access to my system here.
And that would be 73 days credit.
Ms. Heisel or Mr. Wright, can one of you display the motion to adjudicate? Can you make it a little bit larger?
Does that help, Judge?
Just hit that little plus there.
Say that again, Judge.
Hit that little plus button up at the top middle of your screen there. Yeah, hit that about 5 times.
Okay.
Couple more. It sucks to get old. Right there, perfect. There we go. All right, Mr. Estrada, I'm having displayed your motion to revoke your community supervision. It says that on April 6th of 2020, you appeared before the court and you pled guilty to assault of a family or household member, a third-degree felony. That the court received the evidence and followed the plea agreement in your case, convicted you and assessed your sentence at 6 years confinement in the Texas Department of Criminal Justice. And the court ordered you to pay a $1,500 fine. The court suspended the sentence on that day and placed you on 4 years community supervision. And Ms. Heisel, if you scroll down a little bit, so I want to show him the counts. And so here you can see where the state has alleged in count 1 and count 2. You're going down.
Yep.
And then count 3, 4, 5, and 6.
I believe that's it, Judge.
All right. So you got an opportunity to review this motion to revoke with your attorney, Mr. Schmidt.
Yes.
Are you pleased with Mr. Schmidt as your attorney?
Yes.
And you feel like you've had enough time to talk with him about this motion and your rights to the point where you've got all the answers to your legal questions? I'm sorry, I couldn't hear you.
Yes, sir.
Okay. And Mr. Schmidt, do you believe that your client is able to enter into this plea agreement with his competency?
Yes, sir, I do.
Okay. And so you're saying that the agreement is to are we pleading true to those, or we're going to withdraw that? We're just going to withdraw that, and those are going to be preserved for future allegations if he's unsuccessful at safety.
That's correct.
Yes, Your Honor. State's going to preserve.
All right. So Mr. And I'm sorry, I've forgotten your name. What's his name again, Mr. Schmidt? Say again. Can't hear you.
Estrada.
Estrada. I'm sorry, Mr. Estrada. My apologies, sir. So, Mr. Estrada, you're telling me that you're willing to go down to SAFE-P, the Substance Abuse Felony Punishment Facility, the rehab portion of TDC, to where you can work on getting help with your drug addiction. Is that right? And so if I send you down there, you're actually going to go down there and work hard at trying to be better. You're not just going down there so you can avoid going to prison. Is that right?
I'm going down there to get out together, and get off drugs and do right.
Good. Okay. All right. Court will approve the agreement. The court will grant the state's motion to withdraw, the motion to revoke. Court will amend the conditions of community supervision to include SAFE-P as a condition and the applicable back time as conditions of community supervision.
And Mr. Schmidt, just before we move on, could you tell me what that number was one more time? How many days back time credit?
Well, I think there's 70. I think we've tapped out at 180 according to Joe.
Yeah, that's what I was making sure. Judge, just for the record, he had 104 days eaten up on a previous MTR. So I was just making sure that the number on this judgment didn't exceed 180 days.
No, it'll be 73 days included in the amendment,
Okay,
but there is no judgment at this point. So I believe that totals 180.
Thank you, Mr. Schneider. Next, Mr. Schmidt.
Judge, I've got the paperwork now on Miss Rogers. It takes about 5 or 7 minutes to get that done.
Okay, go ahead. Let's see, who else do we lack here?
We have Mr. Peters.
Yeah, go ahead, bring Mr. Peters up. All right, you're Peters, is that right?
Yes, sir.
Mr. Peters, it looks like the state has filed a motion to revoke your community supervision. Do you intend to request a court-appointed lawyer? Or are you going to hire your own attorney? You can represent yourself. What's your plan on how to resolve this motion?
No, I'm gonna request a lawyer. I was appointed Casey Ashmore already, and I'm not even on probation in this county. I don't have any community supervision of any kind in this county.
Well, you were appointed Casey Ashmore on your underlying charge of driving while intoxicated, and he got you probation, right?
No, I've never signed for probation here. I've been in Collin County for 9 months now. I just got here a week ago, 2 weeks ago.
When you originally got put on probation, you're telling me you've never been convicted in this county and put on probation in this
No,
county?
sir. No, sir. This is my first time ever in this county. I went to prison last year for a third or more DWI, and I've charged that parole since. And this is a charge that happened 2 years ago on New Year's Eve of 2020. I was never arrested on this charge. I've been released from prison since then. For a previous DWI.
Did you get the DWI here in Van Zandt County?
This one, yes, sir. I got this one in Van Zandt. Never was arrested or anything on this charge until recently. I came here on this is a brand new charge. I've never had anything, never been here.
Okay, well, yeah, let us look into that then for just a second. Ms. Heisel or Mr. Woodwhite, can you just?
Judge, that looks correct. The only docketing setting I ever have him for is for this one. I don't know why it's marked as an MTR. In our system, we have that it was indicted, that we filed a pretrial letter with offer. We requested an after indictment warrant and Mr. Ashmore got appointed, and then we have nothing subsequent to that.
Your letter, the order appointing Mr. Ashmore, this cause number?
Let me look, Your Honor. Yes, Your Honor, and it is signed January 21st of 2022.
So Mr. Ashmore, he has been appointed.
I was in Collin County during that time as well, and I have tried to reach out with different motions and plea agreements. I've never been able to talk to him at all. So I have no idea where this case was headed or anything, but I did sign for probation over there on a different charge, not related to this at all. So I'm not sure how that works here.
Yeah, that's what we're going to try to figure out. Mr. Ashmore was here earlier. He remembered you and he thought he had been appointed. But our initial records indicated that maybe we thought it was a motion to revoke and that he had been appointed on the underlying case. So, Ms. Abraham, are you there? Ms. Abraham?
Yes, sir.
All right, we need to get to the bottom of Mr. Peters' appointment or non-appointment of indigent defense counsel. Did you hear what he had to say?
Yeah, I'm trying to look. Hang on just a second. I know, but where did the MTR come from?
He removed me from this meeting.
I had, we were creating a sound loop and we couldn't hear you.
Okay, Your Honor, I'm confused because it looks like Casey Ashmore was appointed on January the 21st. We got a letter from the defendant. Hang on. So I think this should have been an arraignment.
I agree, Your Honor. I'm looking in the clerk's side and it doesn't appear that he's ever appeared on this charge.
All right, so Mr. Moore was right. He had it on his docket. All right, so Mr. Peters, what we're going to do then is Mr. Ashmore has been appointed to represent you. And he was here earlier and I told him we were going to try to figure out what was going on. So what I'm going to do is I'm going to reset your case and we're going to have him get in contact with you between now and the next court date. Okay. And then you're going to relay all that information that you relayed to me. You're going to tell him about your travels and where you've been and what you signed for and all that so that he can get with Ms. Heidel and Mr. Woodwife, the prosecutors here, try to get you figured out. Okay.
Yes, sir.
Okay. All right. So I'll tell you what I'm going to do. I'm going to reset you for Miss Abraham. What did we reset Mr. Ashmore today for November 8th or 10th? I don't want to reset it too long.
Let me see. We reset him to.
Looks like he'll be here November 8th on Mr. Enoch's.
And then November the 10th. No, that's Mitch. I'm sorry.
All right. So let's reset Mr. Peters then for November 8th at 1:30. We'll send him communication today that he is, in fact, he appeared earlier, was asking about you, but our records were not right. His records were right. Ours were not. And so if y'all can make sure that you have discovery turned on for Mr. Ashmore. All right. Thank you, Mr. We'll see you back on the 8th.
Yes, sir. Thank you very much.
And Mr. Peters, if you get out on bail, your hearing will be at 9 a.m.
Okay, no, I'll be, unfortunately, I will still be here waiting. Like I said, it's been 9 months already, so I'm just trying to get it all over.
Are you on a TDT sentence right now?
No, sir. I signed for probation in Collin County. I was there for 9 months, almost roughly. I've been locked up 9 months today. Signed for probation over there, and I'm just hoping to get probation to run concurrent over here. I've got released from TDC in July of last year, and got a 9-to-5 job, started working. I didn't even know I had this warrant.
Okay. All right. We'll get this to Mr. Ashmore ASAP and maybe we can get you figured out quickly. Okay.
Okay. Thank you very much, Judge.
You're welcome.
Mr. Hensley is coming up now.
Hensley,
Yes.
does he have a lawyer or non-lawyer?
Is Mr. Schmidt.
Oh, Mr. Schmidt. Okay. Like I said, I'm working on my phone today, so it's real hard to keep track. Hey, Patty.
Yes, sir.
How many more do you show that we have on the docket?
I just show Mr. Hensley, which is Richards, and Joshua Morgan, which is Mr. Smith's, Jamie Nash, Brianna Rogers.
We've already done Jamie Nash, haven't we?
Yes.
Oh,
Yeah,
we did? Okay.
and we did Mr. Morgan too. So, yeah,
Okay.
Hensley,
Hensley, Rogers. I think that's it.
okay.
We need to talk about Cody Ledbetter, but that's all I showed.
Okay,
Can we talk about Cody Ledbetter while they're getting someone?
let's do it.
Okay, we had him set, we verified that he's in the Beto unit. We need to figure out if we're going to bench warrant him back. He's in TDC on a Kaufman County charge. And I believe the state wants to continue prosecution.
Yes, I know Mr. Schmidt and I talked about Mr. Ledbetter, in light of his plea. Yeah, I believe that we agreed to have him benched back here so that Mr. Schmidt could communicate with him, and that we could make a new offer in light of his, plea. I know the state at this point is not willing to give him a concurrent plea, but, I believe that Mr. Schmidt would like him to be benched back so we can all discuss together.
Actually, I'd like the state to dismiss their case.
Well, within what the state is willing to do, Mr. Schmidt, is my understanding that Mr. Schmidt believes that's the best option.
All right. So is there any questions, Patty?
So do we want to bench him like December 13th? His
Yeah,
projected release is like July of 2024.
Yeah, let's bench him December 13th. Is that fine with you, Richard?
Yes, sir.
Yeah, let's just bench him December 13th and we'll give sheriff's office time to get him.
Okay.
All right. Are you ready on Hensley or Rogers?
Yeah, we can arrange Hensley and then be ready on August.
All right.
And Judge, just
Awesome. Yes. Yeah, this is Austin Keith Hensley, CR 22274. Set for arraignment. Go ahead, Mr. Schmidt.
Judge, I received a copy of the indictment, understand what's contained in it. His name is spelled correctly. There's a plea of not guilty, wait for the set for a pretrial on the 11/8.
11-8. All right. Court will find that Mr. Hensley has waived the formal requirements of arraignment. Court will enter his plea of not guilty into the record and set pretrial on November 8th at 9 a.m.
Thank you.
All right. Who's next?
Brianna Rogers.
Ms. Rogers, if you'll come forward, please. This is cause number CR 21236, State versus Brianna Christine Rogers, set for.
Set for a plea, Judge.
Okay.
Ms. Rogers intends to plead true to the state's motion to revoke. The state's agreed to offer a plea offer of 7 years TDCJ in order to pay the balance of her financial obligations. She has 218 days credit time towards that sentence.
Did you say 215, 215?
218.
218, thank you. 218, all right. And Ms. Heisel or Mr. Woodward, can you throw the motion to revoke up there for me? Ms. Rogers, if you'll raise your right hand. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? Ms. Rogers, are you pleased with Mr. Schmidt as your attorney?
Yes, I am.
You feel like you've had enough time to talk with him about your case and have all your legal questions through?
Yes, sir.
Is there anything about this paperwork that you've signed today that you do not understand?
Yes, sir.
And you heard the plea agreement from Mr. Schmidt. He's telling me that this motion to revoke that we're about to go over, that you intend to plead true to all counts, and you're asking the court to follow your agreement wherein the court would find that you have violated your community supervision, revoke that community supervision, and sentence you to 7 years in prison, with ordering you to pay the balance of your financial obligations and awarding you 218 days credit towards your sentence for the time that you've spent in jail on this case. Is that your understanding of the plea agreement?
Yes, sir.
All right. And Mr. Schmidt, do you believe Ms. Rogers to be competent to enter into this agreement?
I do, Judge.
All right. And you've explained to her rights as they pertain to this motion?
I have.
You see on the screen there, Ms. Rogers, it says that on December 16th, 2021, you appeared before the court. You pled guilty to a first-degree felony offense of manufacture delivery of a controlled substance. The court heard the evidence, found that there was enough evidence to convict you, and the court followed a plea agreement on that day and assessed your punishment at 8 years confinement in prison. But the court also ordered you to pay a $4,000 fine. The court then, pursuant to the plea agreement, suspended that sentence and placed you on community supervision or probation for 5 years. And it was during that period of your community supervision that the state has alleged multiple counts of ways that they are alleging that you violated your conditions of community supervision. You see there count 1 and count 2. And then counts 3, 4, and 5. And then 6, 7, and 8. So there's a total of 8 counts. You've gone over those with your attorney, Mr. Schmidt, right? Okay. All right. So at this time, I'll ask you, Ms. Rogers, how do you plead to counts 1 through 8 as contained in the state's motion? Are those counts true or not true?
True.
And are you pleading true to those counts because what is alleged is in fact true? You're not just saying that so you can get a certain plea deal?
Yes, sir.
Okay. All right. The court will accept the defendant's plea of true. Mr. Schmidt, any objection to the state's evidence?
No objection.
All right. State's evidence is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we had rest and close at this time.
From the defense, Mr. Schmidt?
Nothing further.
All right, Ms. Rogers, the court finds that based on your pleas of true and the evidence offered that you have violated the terms and conditions of your community supervision. Court hereby revokes your community supervision, assesses your punishment at 7 years confinement in the Texas Department of Criminal Justice, orders you to pay the balance of your financial obligations, and awards you 218 days credit towards your sentence for the time that you have spent in jail on this cause. You're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm gonna have you step over with a deputy to be fingerprinted. Good luck to you.
Thank you.
You're welcome.
I think we've addressed all of the rest of my cases already, Judge.
I think so too. Ms. Taberham, can you confirm or state? I don't have it. All I got is some notebook paper. I don't, where I've been doodling. I don't
That
have.
appears to be all that Mr. Schmidt has based on my docket, Your Honor.
Is there anyone else that's not been called on the afternoon docket?
Not that I see.
All
I
right.
don't see anyone else, Your Honor.
Sounds good to me. Thank you, Mr. Schmidt. Appreciate you, sir.
Thank you.
Thank you. Thank you, Hillary. Thank you, Tyler. Appreciate you. Thank you, Patty. Thank you, Wayne. Appreciate y'all's help today.
Are you
I'll be-
gonna come by?
One of it, either Mr. Heisel or I will come by. I think there are Ms. Heisel, I'm sorry. I'm gonna hear about that one later, Judge. We'll come by and sign. And Judge, if I could speak to you off of the YouTube briefly about a procedural matter. I just have a question for you.
Sure.